SJC-13731, Commonwealth versus Jairin Perez.
Okay, Attorney DePalma.
Good morning. May it please the court, my name is Valerie DePalma, and I represent Jairin Perez. On March 22nd, 2024, this court issued its revised opinion in Mattis. In that revised opinion, it set out a parole eligibility scheme for emerging adults who had been sentenced to life without the possibility of parole. It divided that cohort into three groups based on the dates of their offenses. The first group were those whose offenses occurred after 2014. And with respect to them, judges have discretion to sentence them to a range of minimum terms based on the theory of murder under which they were convicted. The second group were those whose offenses occurred between 2012 and 2014. With respect to them, judges have discretion to sentence them to a range of parole eligibility range between 15 and 25 years. And the third group are those whose offenses occurred before 2012. With respect to that group, this court stated that they shall be eligible after having served 15 years in prison. This scheme cured the constitutional defect in the emerging adult sentences. It excised the parole ineligibility components of their sentences and replaced them with a parole eligibility term, either discretionary or fixed, as in the case of my client. Which comes to my point that the revised opinion in Mattis fixed Mr. Perez's sentences. It replaced the parole ineligibility provisions of the concurrent sentences, and because his offenses occurred before 2012, it replaced that with a 15-year term. When the rescript in Mattis was issued, he had already served 15 years in prison. So as a result, he was immediately eligible for parole. And for that reason, resentencing is not necessary in this case. All that is necessary is correction of the minimuses, which will then permit him to seek a parole hearing. Admittedly, I filed a motion for resentencing.
Right.
I'm sorry?
Well, if I can stumble through my question, I'm sorry. The question I have is, as far as correction of the minimus versus resentencing, what's the authority that you have that correction of the MIT is not a resentencing?
The case is holding that, I believe Blakey is one, that it's a ministerial act, that it...
Is that ministerial when someone gets 126 days credit and they get 12 days because they forget the 6?
Yes, yes. Yes, it is. It's like, for instance, a clerical error.
It's when the minimus does not accurately reflect the sentence,
Yes.
correct?
Yes.
But that's not the situation here. The minimus does accurately reflect the sentence he received. So how could the minimus be changed without also changing the sentence?
Because the minimuses, Mr. Perez's minimuses reflected his original sentence imposed in 2002 by the sentencing judge. It does not reflect the sentence.
But he hasn't received another sentence. What's happened is Mattis was decided. Mattis didn't actually mechanically change this defendant's or any defendant's sentence. There still needed to be an act that would change the sentence?
Well, my position is that by operation of law, Mattis changed the sentence, and that's supported by, well,
It decided what he would be entitled to as part of his sentence.
yes. Yes,
Okay.
it did. I mean, I don't think it either left.
It didn't leave any discretion to the judge to say, for example, you, Mr. Perez, are not going to get a 15-year parole eligibility. But I don't know that it means that Mattis said that the decision in Mattis mechanically altered any individual defendant's sentence, including Mr. Mattis's. It didn't make the mechanical change itself to the sentence.
Correct. No, the court records reflected their original sentence.
And that needs
that's-
to be corrected somehow.
And the question is, is a resentencing hearing necessary to do that?
Well, how else would that happen? It can't happen by simply changing the minimus.
I think it can. I think, in fact, in Costa, that's what happened. In Costa, which I note in my original brief, the original motion, the first motion that was decided was a motion to correct the minimus.
Right, but.
And then the defendant sought resentencing. But Costa's a little further down the line in this argument. But my point, I see what you're saying, but I think my point is resentencing is necessary if there's a sentencing package.
But wasn't there a sentencing package here?
No, they were concurrent
But
sentences.
Every single case I saw where there's concurrent or two homicides, it says it's a package. It says they're dependent sentences. Every single case.
Well, I think the court has to.
I don't want to go through them, but every case
But-
says they're
well,
defendant.
I guess my point about Mattis correcting the sentence by operation of law is that the Supreme Court in Montgomery versus Louisiana, after it ruled that life without parole was a retroactive rule, it then said, don't worry, state courts. You don't have to resentence everybody. If you provide parole eligibility, either through a statute or through a judicial decision, their sentences are fixed for constitutional purposes. There's no reason to resentence every single person, which of course would overwhelm the lower courts with lots of resentencing hearings. And I agree, Justice Gaziano. In fact, in Mattis itself had concurrent non-homicide offenses. So if the rule that the Commonwealth is seeking here, that it is entitled to resentencing anytime there are concurrent sentences in these cases, that's going to open up pretty much every single case.
Well,
to resentencing.
given the procedural posture that we're in, where there's not actually been any kind of sentencing hearings, isn't sentencing hearings could be different kinds of proceedings, right? There could be just a hearing where the judge says, well, Mattis, guess you get parole at the end. Or it could be a full possibility of parole. Exactly.
Right, possibility, yes.
But it also could be, as you're suggesting, and as the Supreme Court was suggesting, was not necessarily going to be necessary, a full sentencing hearing. And we don't know at this point, in this case, what is contemplated, and we don't have to decide that, correct?
Correct, but I think in many of them, and certainly in this case, the reason when the judge asked me, when do you want to do resentencing? And I said, I'll let you know, because first I would have to get money, and then I would have to find an expert, and then I would have to, in other words, the resentencing, and I would expect most of these cases have to have an expert who's going to testify.
I'm looking at all the Dachenko cases, and they all say they're going to be remanded for resentencing. But assume we don't agree with you on that. How is this and we think it's a sentencing, not just a minimus error. How does this violate double jeopardy when the expectation of your client at the time of sentencing was life without the possibility of parole?
because when this court decided Mattis, his expectation changed. And the support for that is the Jones versus.
So I guess it's circular because the question is whether his expectation crystallized. He gets the benefit of Mattis. He hasn't been resentenced yet, so it's still up in the air, correct?
Well, I don't agree with that, Your Honor. I think that Mattis comes out, says you are eligible for parole after having served 15 years. It does nothing to disturb the concurrency of his sentences. 60 days go by, the rescript from Mattis issues. I believe that gives rise to an expectation of finality. And in the Jones versus Thomas case,
Even with Costa saying, when you have consecutive sentences, we should have a resentencing hearing to determine whether they should be concurrent, given now we have different consequences?
because the difference is, what the critical difference is that in Costa, it was the defendant who moved under Rule 30A for resentencing. And the defendant can move at any time.
It's a one-way street.
Right.
It's a one-way ratchet, is how I was encouraged to describe the Costa rule. The Costa rule works one way and only one way. And that's because of double jeopardy. Because Costa wanted to have his sentence reviewed.
So is your position that if the government had, within 60 days of the issuance of the Mattis rescript, move for resentencing on your client, that there would be no double jeopardy problem?
I'm not conceding that, no, because the other issue, if the
But when, in response to Justice Gaziano's question, you said that his expectation of finality crystallized, I thought you said within 60 days of Mattis.
that's correct.
Okay, so that was the only issue that would present some sort of double jeopardy problem.
Well, the other issue I'd like to point out is that under the Commonwealth can only seek modification of an illegal disposition within the 60-day window provided in Rule 29A1. Mr. Perez's sentences were no longer unconstitutional. And that's what,
Well, it seems to me all of your arguments seem to hinge on this notion that Mattis effectuated some kind of change to your client's sentence directly, that it actually directly changed the sentence.
I think with respect to him, there's no argument about you've served 2 life sentences for over 23 years, or at that point, the court issues a decision saying the without parole part, that's unconstitutional. With respect to people whose sentences occurred before 2012, that is a fixed term.
Let me
They shall be eligible.
let me put it to you differently. If you didn't move under Rule 30A, and the government also did nothing, his sentence would still remain 2 convictions for of murder in the first degree, with a mandatory sentence of life without the possibility of parole. Someone had to do something to change that.
That's correct, but the question is, under what type of proceeding? And in fact, in Mattis, the sentence was corrected via a motion to correct the minimus.
Can you turn to the time eligibility part of the case on double jeopardy?
Yes.
What I didn't see was a discussion of the statutory provisions for parole eligibility for concurrent sentences and how that affects our analysis.
Well, the statutory,
I'm looking at Dinkins versus the Parole Board in section 133 and 130 of chapter 127.
section 133 of 127?
Right.
Yeah, according to that, it says the parole board has to establish a single parole eligibility date And it says, when an inmate is serving 2 or more consecutive or concurrent state prison sentence, a single parole eligibility date shall be established for all sentences.
Right, so he gets one date on both sentences, and we said in Dinkins, you can't do what they used to do.
Right, aggregate.
Aggregate, exactly. So doesn't that relate to your client's parole eligibility and answer your double jeopardy claim on dead time, essentially?
I don't think so, because I think that someone who's serving all, if all their sentences are concurrent, I believe it's based on the longest sentence.
Right.
Right. So here,
So he gets credit for time served.
Yes.
And parole eligibility throughout his tenure on both sentences.
yes. Well, I mean, my argument, if Mr. Perez were being considered for parole without having.
But we don't know, because if the judge, if this gets we don't know. So if the judge is saying, if it's him, if he gives him concurrent sentences, this is all moot.
Correct.
If he gives them from and after, then we're talking about parole eligibility, correct?
Yes, yes. I mean, if they were from and after, they would have to be aggregated. If
Right.
they were concurrent, they wouldn't.
So that speaks to your last claim about double jeopardy. And
Yes, and yeah, the double
no,
jeopardy.
I guess the question for you is, isn't that taken care of by the statutes?
Well, not necessarily. I mean, I think it would be, because the issue too is unless the minimus is corrected, we can't ask for a parole hearing.
Right, which and that's going to entail the resentencing
Right, well,
on remand, right?
right. But I would just wanted to get back to the point that, Costa is fundamentally different, that it was the defendant there who moved under Rule 30A. The Commonwealth, in this case, is,
You kind of did first, but
I'm sorry?
you kind of.
I
found it.
did, and I
Right.
admit, I admit that what I intended was to move for correction of the minimus. And as I said, that's because the parole board won't entertain requests for hearings without a corrected minimus. And that there was a lot of confusion at the time, post-Mattis. Mattis said was remanded initially for resentencing, then after the revised opinion, it was remanded for further action. So in the defense bar, there was a lot of questions about how to proceed in these cases. So I agree, I did file it. My intention, however, was not to have a resentencing hearing in the sense we're now talking about. In addition, I just was checking, and again, just going back to my point about if the Commonwealth's position is accepted, most homicide cases, as were mentioned, involve multiple charges. Frequently, they're concurrent. And is resentencing hearing going to be necessary?
Well, we said that in, we remanded for sentencing. That was exactly the issue in Wiggins, where a person had a Dichenko resentencing, and there were other crimes, and the judge gave him non-murder offenses, and we said in that case, the judge, thought this was irrelevant when the judge sentenced him on the non-murder cases, but we're going to remand it so the judge can consider the sentencing package,
Right.
right? Because at the time, just like on 2 murder cases, in non-homicide cases, when someone was presumptively life without parole, the judge below, just like Judge Chin, gave this very little thought because it didn't mean anything back then.
That's true, but just because Mattis changed the law and created parole implications where there previously hadn't been any, doesn't mean that his exercise of discretion was improper in any way.
What would happen here in this case if we disagreed with you, it went back for resentencing, and the judge decided to give on and after consecutive sentences, life sentences, what would happen to your client?
Well, as I argue in his brief, that is an increase in the aggregate sentence. That would also amount to a double jeopardy
What
violation.
I'm asking specifically, how many, when would your client in particular, be eligible for parole?
Well, it would add an additional,
How many years has he been in?
he's been in 23, more than 23, so an additional 7 years to what he would have to serve. But our argument is also that, imposition of consecutive life sentences with parole eligibility after, 30 years would double his sentence, both the aggregate and the parole ineligibility period. And under the Shabazz case, that is a double jeopardy violation. And it had very similar facts to the one here. And finally, the final argument with respect to double jeopardy was with respect to his sentencing credits, that those should be awarded similarly to pretrial credit, jail credits. The Carter case held that pretrial detention credits should be awarded against each concurrent sentence a defendant is serving, and therefore, I think credit for time actually served on a sentence should be awarded in the same manner and remain consistent with that.
What would your clients, if we were to say that's correct, where would that leave your client?
Well, it would leave him as having served, of course, 23 on each, and if those were, the sentences were restructured so that they were stacked, he would have to serve 30, and he would have served well more than 30 at that point.
Would he not get credit for the 15 he served concurrently on each sentence?
That's what my argument
So,
is.
in fact, he would be immediately eligible for
Yes.
parole? Okay.
He still would be, yes.
And that could be by application of the statute, correct?
Yes, presumably, yes.
Right.
Okay,
There's no further questions. I'll rest on my briefs. Thank you.
thank you. Attorney Eisenhower.
May it please the court, Rachel Eisenhower for the Commonwealth. This case presents the question of how a new constitutional ruling at a state Supreme Court level flows outward to other people who are affected by the case. And I think what is necessary to understand it is to look at who's a party to Mattis, and unlike in the civil case where we have things like class actions, we don't have class actions in the criminal context. So what we have is a single defendant who seeks relief, and then other people similarly situated after the decision bring themselves forward to the court and raise their hand and say, I'm entitled to that relief. And other branches of the government help. This court writes right in his opinion that it's going to be applicable to everyone. After Mattis was issued, the DOC reached out to my office with a list of people it thought. Our office gets involved. The CPCS gets involved. So everyone's trying to help these people come to court and get the relief that they're entitled to under Mattis. And when you see that, I think that you see what I would describe as an ellipsis in procedure sometimes, because it would not make any sense for each of those people to have to remake the Mattis record, remake the Mattis argument before this court. That would be unnecessary. It's been decided here. So they go to Superior Court, and they're looking for application of the Mattis rule. And in some cases, where they're serving a single sentence, as Mattis was, they're ellipsizing the sentencing hearing procedure because there's only one result. And that's why they're seeking correction of the minimus, not because it's like a situation or analogous to a situation where someone has written 126 instead of 12 or vice versa, but because it's a situation where the result of the hearing is a foregone conclusion, and so to conserve judicial resources, everyone's trying to move it forward and get this efficiently rendered.
Do you think that the result of, if we agree with you that there should be a resentencing hearing, that the result of that hearing is a foregone conclusion?
No, and I think that's why, in this case, the Commonwealth sought a resentencing hearing, because there were multiple options, in our view, of how the defendant could be sentenced, because had the post-Mattis sentence for first-degree murder been in place in 2002 when Judge Chin was conducting the sentencing, he would have faced two choices. He would have faced the choice of, do I impose concurrent life sentences for the murders of these two people who were shot, or do I impose consecutive sentences? And it was a tough choice, because they had the youth of the defendant on one hand, which I would expect to be urged by my sister at the resentencing hearing, in addition to the new science that was at issue in Mattis. I would expect that. And on the Commonwealth side, I would expect, as in any sentencing hearing, that we'd be discussing the facts of the crime, the impact on the victims, the impact on the community, traditional sentencing factors. In addition, the Commonwealth would likely discuss the science as well, not as an aggregating factor, but as to rebut the potential mitigating factor, because the question of hot versus cold cognition and all those brain development factors, they don't necessarily apply equally to all.
Understanding that it may still be a meaningful decision in a sense about whether the judge imposed on resentencing concurrent versus consecutive sentences in recognition of the nature of everything you've just discussed. As a practical matter, how does that shake out in terms of the parole eligibility date of the defendant?
So my understanding for Perez, if he were resentenced to concurrent sentences, my understanding was that he would be parole eligible after 15 years. Now, under Mattis, it's non-protonc, so it would be deemed to start, that 15 years would start in 2001. So he would be already parole eligible.
Because he's served 23 years.
Because he's served 23 years. So if we're counting to 15, we're already there. If we're counting to 30, we get there in 2031 by my math.
But what about the statute, though? That's the problem. Could you address the statutory provision that says that when someone is sentenced to consecutive or concurrent, the parole board sets, we set one parole date, and then you look at Dinkins, and Dinkins says, you look at the aggregate, but here you have two life sentences, right? So they wash, basically. So can you address statutorily why they would not be parole eligible?
So honestly, Your Honor, I'd never considered that before you raised it today. So I had taken for granted that it was 15 years versus 30 years. I had not read the statute to suggest something differently, and I hadn't read Dinkins to suggest something differently. Is your reading of the statute?
It's not an answer, it's a question, so that's why I want your input. And if you haven't looked at it, that's fine.
If the statute could be read to say that a defendant can serve concurrent sentences, and then if there's a defect in one of the sentences and resentencing is called for, it's constitutional to sort of wipe out the time that the defendant served on one of the concurrent sentences and just start as if the defendant has not served any time on that sentence consecutively?
So I would have described that in different terms. I would have described that as crediting with every day he did serve under a package. And the reason with that is just because under North Carolina versus Pierce, I hate the idea of wiping out time, but I don't think we are wiping out time. I don't think we are saying he served dead time. I think we are saying he served package time.
And that's the question I had about dead time as well under Henschel. If he's not getting credit for the 15 on both of them, is there dead time?
No, Your Honor, because under a sentencing package theory, he's getting credit for every day in prison.
The package theory, though, goes to my understanding, and tell me if there are cases that say something different. My understanding of the idea of a package is the natural point that when the judge is considering what sentence to give for a particular offense, the judge is looking at the totality of everything the judge has in front of the judge. And so if we have to post hoc disturb one element of that, because the judge was necessarily looking at all of it, we should send it back and the judge can do whatever.
Yes,
And
Your-
assuming we agree that that's true here, right? This was interdependent, et cetera, it should go back. But that seems to me a different question from whether the defendant has served time on a sentence. And it seems to me that here he was sentenced to concurrent sentences, and so he was serving 23 years on each sentence. What's the best case you have for the proposition that it's consistent with the double jeopardy clause to ignore that he's served 23 years on one of these sentences?
Rosier out of the 11th Circuit and the habeas case out of Wisconsin would be the two best cases for that proposition.
But you have no other case law.
No, it's a very unusual proposition.
Well, and the Supreme Court has said that, I think it used the word absolutely, that time served on a sentence absolutely counts.
Yes. Now, are you quoting from, I think you're quoting from Pierce, time served on a sentence. And one thing I would note about Pierce is that Pierce comes from an era where the sentencing package theory wasn't really the dominant criminal law theory. That's kind of a late 20th century theory of analyzing things in terms of a package.
But but that doesn't address my point that the package theory is about how we think about what the fact that the judge was considering the thing as a whole. But in this case, it's undisputed. The judge, considering as a whole, did give concurrent sentences, correct?
Yes, but we're looking at a judge who had a very constrained batch of choices. We're looking at a judge who had 2 murders, both with mandatory sentences, and the only element of discretion he had at all was the word concurrent or the word consecutive.
Back then, it didn't mean anything.
Which back then didn't mean anything.
That's what we've said repeatedly, that when it was life without parole, whether it's 2 murders, whether it's a murder plus other felonies, it doesn't mean anything.
It's true, Your Honor. Now, as for a sentencing package, I don't think lack of complexity negates it being a package. I know if this had been a more complex structure with more blocks, then taking a big block off is the classic sentencing package thing. And maybe I'm misconstruing your question, because I was construing your question to say that because there aren't that many pieces and hasn't been a major shift, we shouldn't treat it as a package. Maybe I misconstrued you.
No, I think, I think her question, Justice Stewart's question is actually, and I don't want to speak for her, is, but maybe I will, is regardless of whether it's a package, how can you support the notion that the defendant will not get credit on each sentence in the way that he already has? He has an expectation that comes from his original sentence. His original sentence was concurrent.
Okay.
And he's been serving the sentence in that way, getting credit on each sentence simultaneously. That's the definition of concurrency. And so whether it's a package or not, you may be able to resentence, but how, and revisit the component of whether it's concurrent, but how do you make the leap to say, and then you can take away?
I understand, Your Honor. If we accept all the premises of your question, then no, we could not say that. The issue is that I do not accept the premise of your question, which is that time is linked to each sentence. Instead, I'm advocating for sort of a legal realist point of view, linking the time served on a package. I believe that theory is pursued in the federal system.
Well, let me push back for a minute and give you a hypothetical.
Okay.
Let's assume the exact same sentence as occurred here. But for some reason, and he's 23 years into serving it, and for some reason, one of those convictions goes away, is reversed, removed. Does that mean he doesn't get credit for the 23 years that he's been serving on the other?
So I think I'd need to know a little bit more about it, but
I think the answer would be no, right? I mean, how could it be anything but?
So if he's serving
He
one
has the
life
exact
sentence,
same sentence that he has here.
and he's okay, and one of
And
these was
23
reversed.
years into his serving the sentence, one of those convictions goes away for some
Yes.
reason.
He would retain the 23 on
That's
the, on the
right.
parallel case.
So
The di-
so then how can you take that away simply by splitting the two from being concurrent to consecutive?
So in my mind, the difference, Your Honor, is, and I realize I'm coming back to the sentencing package doctrine, but I'm rebuilding something from pieces. The building blocks came together in the initial sentence for the practical effect of having life imprisonment with no possibility of parole. And the practical rebuilding of this doesn't take away the fact that he's been in for 23 years. What it does is it looks at the fact that we've got two fundamentally different building blocks. And that, I think, is the distinction from your case, where simply one of the blocks has disappeared. Why should the other change? Here, both blocks have changed shape. They're smaller blocks. And so rather than shrink the entire thing, we should be able to go back and ask a Superior Court judge, because I believe ultimately this is a case of sentencing judge discretion. Sentencing judges have this unique role to do this individualized hearing and individual weighing and balancing. They're a unique part within the justice system of being able to do that and to take on that role, to hear the evidence and apply it in an individual case. And I think sentencing is best done at an individual level. And that's why it should come back to that.
And can I ask how, I'm a little confused of if we agree that there should be a resentencing and agree that consecutive sentences are possible, the judge is doing, I'm just trying to figure out what the judge is doing and whether it's consistent with our reasoning in Mattis. I understand if he's just doubling because there's two murders. Are you also saying he's supposed to look at, re-look at the depravity and youth and all that again?
Well, if you...
Didn't we reject all of that in Mattis? That they're... I'm just trying to understand. I'm afraid that we're going to generate a whole new set of issues.
But didn't we do that in Costa, though?
So that is what we did in Costa. We went to look and ask the question of, is he so young that he should, we should take a look at this. It was essentially a double application of the Mattis science to see whether, in addition to having broad applicability to the class, it had specific applicability to the person that should be taken in mitigation.
Costa, okay, all right. So we're opening up just what your sister argued, which is that we're going to have experts go back and do the depravity and...
Well, there are two ways...
And just those three, I can't remember the three, the subject to change, the irreparable depravity, all the...
Hot, cold cognition.
We're going to go back and do all that each time we do a consecutive versus concurrent one?
Well, I mean, I think that there are two ways to go with that. The one way to do it is to say that these sentencing factors can have individual applicability, and it would be, I don't think it would be fair to take that off the table for the defense. If they want to argue the science, shouldn't it be their right to argue the science, even on an individual basis?
Even after we've concluded that these 18 to 20-year-olds, you cannot make a determination they're irreparably depraved. They are more capable of change, whether they killed one person or two. I'm just trying to get a sense of what we're unleashing here.
So, I mean, there are two issues. It's traditional sentencing factors, but also the science. And so as in any sentencing judge's consideration, and this is one of the reasons that Superior Court judges have such a hard job, is that they have to weigh very hard things going in both directions and take the gestalt of that and make what is sometimes an impossible choice.
But again, a key part of Mattis was saying we're not going to require them to do bad science that defined irreparable depravity. So I get it if we're just sending it back saying there are two murderers and we can double this if that's what you. But I just don't know how it squares with a lot of the reasoning in Mattis if we're going back to redo the same things we already decided in Mattis.
So as far as the Commonwealth's case go, I'm not intending to put on a depravity case that he should get consecutive sentences because somehow he's depraved and not like other 20-year-olds. Our point will be that there were two people. To the extent there's science, my sister will likely argue, and I don't want to put words in her mouth, but she has a right, I think she has a right to say he's 20 and the science says that that means something notwithstanding the two victims. But I would anticipate that the Commonwealth's argument is largely directed to the fact that we're dealing with two people, the traditional things you would see in the sentencing hearing, the facts of the crime, how it was planned out, premeditation facts, that kind of thing. And this is both a premeditation and an extreme atrocity case, which Mattis wasn't. So yes, those are the things that we would be looking at, traditional sentencing factors, not aside from the Mattis science. I just don't want to tell you that she can't put on Mattis because I think that would deprive the defendant of their right to put on whatever they want. If there are no further questions, the Commonwealth would rest on its brief.